My guest today is a youthful lawyer, but not an advocate. He's clearly intelligent, saying that he passed exams highly going into university and is prone to interesting stands and arguments. You could justifiably label him a social conscious activist lawyer. He has capacity to sue anyone and does not shy away from it, however difficult. He is also a successful moneylender. I am Oscar Semwe-Amsoke, and this is NBS Face Off. Welcome to NBS Face Off, Mr. Male Mabirizi.
Thank you, thank you.
Yes, when I interviewed you in April 2019, I put it to you that you're rather litigious. And I think not many people have changed their minds since.
Yes, because the status quo has not changed. Since April 2019, I think nothing has changed as far as the rule of law is concerned. Maybe I've added on actually more legal was. I think in April 2019, I had not went to East African Court of Justice. I was, I think, waiting for judgment. Where I got in judgment in age limit case at the Supreme Court. We had finished in Mbale. But in May, I went to East African Court of Justice. Then many things have come up then.
Yeah.
From then there was no petition. Then after the election petition, there was no COVID, where M7 issued directives which I think are illegal and which I challenged. There was no, many things have come up which are illegal. Justice Secretary had not been appointed as Deputy Chief Justice without going through the the Judicial Service Commission. So many things have changed.
So you don't accept that you're litigious or that you're a pain. That's other people will say. You think of a name, Male Mabirizi, someone says, oh, that man is a pain.
I don't deny being litigious. Question is...
You don't deny being a pain?
Yes. No, litigious and being a pain are different things, I think.
You think?
they're different. Litigation...
I would say they're on the same page. If he grabs anything and is...
Not anything. I'm strategic in what I pursue. I'm strategic in what I sue for. Actually, not everything that happens on a daily basis that I sue for it. I pick something which maybe most of people fear. And sometimes actually I give them time to see, let me see whether maybe some challenge will come. As time moves, you see nothing is coming. People are accepting that actually this is the... Let me give you an example of the lockdown. Seven comes on TV and radios, he says, I'm now locking up your country. By my word of mouth, people accepted it. I talked somewhere, they said, you see, people fear COVID so much. So if the man can announce, people have taken it. Then I was asking them, but we have laws in this country. Can a man wake up, although he's the president, and say, I'm closing schools, I'm doing this, by word of mouth? Then I say, I think...
Can he?
He cannot under our laws. Yeah. Because Article 19 of the Constitution says, he shall be subject to the laws of Uganda.
Emergency law?
Even a state of emergency must go through Parliament. But this was not a state of emergency. The law which was applicable here was Public Health Act. It specified that for you to do anything to control disease, you must make it through regulations, through statutory instrument. Everything was lacking. The man announced, he says, effective tomorrow, schools should close. And people accepted it. So when such things happen and no one is challenging, then that's when I say, but this is my country, I'm here. Should we just watch as people are accepting to be ruled illegally? Then I say, no, that cannot happen. The same applies here to Owunyidolo.
We're going to go to that in a few minutes.
But the point I'm making is there are situations when everybody is accepting the status quo as it is. That's when I said, no, I think...
You're like an activist. I have described you as a social conscientious activist lawyer. So you're saying you wait a little bit, and if no one is taking action, you have no fear of taking it up. But I also put to you that maybe not many judges agree with you because you don't win many cases. In fact, when you are in an argument with Justice Owunyidolo, you said he'd given you a win recently, and I was scratching my head. Which one was this? Because I do not know any Male Mabirizi win, and it's a problem.
Owunyidolo never just gave me a win. I won.
Which one is this that you won?
The other time I told you I have many wins on different perspectives and on different forums.
On different perspectives, perhaps. But yes. I'm talking about winning a case in court.
Where you say
in court. You've prosecuted something and you have won it.
That one, which I told Owunyiro that I had won, is a case of 2014. Yeah. It said it in 2015. I had a wrangle. It was a business wrangle with my landlord, where he had distressed me for rent illegally. And then when I sued, before Owunyiro said, no, I think, Malay, you are right. This man acted illegally, so let him give you the cost.
Maybe that's an old case when judges were not, I shouldn't say the word fearful, when judges were taking you on merit and believing you had a good cause, rather than now where you are, as I put to you, litigious.
No, the difference is this. The difference is the subject matter. These judges fear shadows. But even recently, I keep on winning cases. And the other time I told you, winning must be put in a proper perspective.
I understood that one. And now, when we see many court cases, especially with presidential petitions, yes, you could say a petition has been lost, but there are recommendations that might improve the electoral process. But here, I made a list of some recent judgments you have lost. Age limit case in the East Africa court, you lost that one. Stopping nominations, you lost that one. Militarization of police, you lost that one.
Stopping nominations.
Kyagulanyi is lying about his age, you lost that one.
No, let's go one by one.
Yes.
So that you are talking about.
And stopping the nominations. Someone will say, Malema Willis, you are being frivolous.
You see, some people are saying that because they are myopic and ignorant, and they don't have the capacity to foresee what I can foresee at that particular moment. The first one you are talking about is African Court of Justice. Yes, I went there, I lost partially, I won partially. The important part I won, which was a very big argument, even before I went to East Africa, even when I went there, from all lawyers here and all over, and government, was that the East African Court has no powers to look into Uganda court decisions. That when a sovereign state called Uganda makes a decision by East Superior Court, that is final. You go to God. But East African Court is telling them no. Under the East African Treaty, we can look into your judgment, into a court judgment, and open it and say, is it compliant with the treaty? Does it comply with democracy and rule of law? That was a very big win. Right now, the gate is now open that when a Supreme Court hangs you, sends you to be hanged, says be evicted from your land, says let so and so take your money, you can go to East Africa and say, look here, Uganda.
So you're saying it is no longer final?
No, it is no longer final. It's no longer final. And now I think even Owunyiro and his group know that as we sit here, whatever we decide is no longer final. We can end up being in Arusha and asked, how did you reach this decision? Did you hear this part?
So what part did you lose then?
Then what I lost, and what I'm appealing against in appellate division, is the aspect where they refuse to nullify that age limit removal. Because I'm saying the process, and they're also agreeing that the process had illegalities. Under normal circumstances, when a process has illegalities, then it has to fall. And I'm saying I won at Supreme Court, but Katwebe never declared me, actually declared a false result. Then they agree that actually, even Attorney General considered that actually Katwebe declared a false result. We had issue number 4 in that petition, whether it was proper for the Constitutional Court to apply the substantiality test, the mathematical, that weighing scale. 4 judges said they cannot. Katwebe announced that 3 had said they cannot. Yet actually we had 1. So I told this African, look at the justice system in Uganda. 4 judges say yes. The presiding officer says
what's your basis of saying 4 judges have agreed to you and 3 haven't, and the Chief Justice has chosen?
That's what happened. Justice Arachi Amoko, Professor Chirukubinza, Justice Mugamba, and Justice Mwangusha said there was no way the Constitutional Court could apply that weighing scale. When Katwebe announced the final verdict as the head of court, he said by majority of 4 to 3, issue number 4 is answered in the negative. That meaning that the judges of the Constitutional Court were right to apply that weighing scale. Yet actually it was the opposite. And when we reached Arusha, Attorney General agreed that said yes, the announcement was wrong.
You'd say it's dated now, it's out of time?
What sort of time?
I mean, the time has gone now. Even if you address that.
No. No. It's still in the South African court because I'm saying that verdict was wrong. Because the moment you say
all you want is to put it right.
No. And to nullify the law. Because the moment you say it was wrong to apply the weighing scale on...
And I'm saying it's dated now. I mean, if you nullify the law, that's i.e. going forward, what happens?
The law is the law. There's a constitutional amendment. It doesn't expire. So let's nullify it. We shall look at the consequences. And for me, that's how foresighted I am. I'm not just simplistic that look at things as they appear on the table. I look behind the table. Up to now, I'm saying Museveni was illegally nominated because the amendment was illegal.
Let's stop for a break, and then we'll pick up another one as well. Thank you for watching NBS Face Off. I am Oscar Semoya Msoke this evening with lawyer Malema Bilizi. The two other interesting cases that you lost, and in my opinion were unnecessary, and maybe the one for militarization of police, perhaps you had a point, but the judges have disagreed with you. But stopping the nominations, or Kyagulanyi lying about his age, and Kyagulanyi is a liar, a lot of people may not have understood you. So you could be understood when you are saying stop the nominations, and immediately after you've been saying that Kyagulanyi is a liar. It seemed like a pattern.
No.
Was it a pattern?
First wait. Stop the nominations for what? You see, I had gone to a South African court telling them that this amendment of the Constitution is illegal. That amendment made many things. One, it removed age limits. Two, it changed the polling timetable. It pulled the polling days closer. It extended the days within which to file in the Supreme Court and when the decision is to be made. So when I was in that court, I told them, as we are waiting, why don't you halt this whole process? Because we are challenging this whole thing. What would happen if, at the end of the day, after this whole thing has been proceeded with, money has been spent, and
like now, if you were to give a judgment
what if the court comes and says, actually, the amendment was illegal? We shall go to a crisis, and I want it to come, if possible.
I don't think so.
You have a president.
A court will just say that is passed, maybe going forward.
No.
But they don't have a jurisdiction to say going forward, this is what you should do.
They do have. A court is a court of law. And actually,
the East Africa Court would not have a jurisdiction to say that going forward, this is what you should. They most likely say, Malema Bilizi, you may be right, and that's it.
Where are you getting that? That is a court. It's a court. It's a judicial body under the treaty. And that's what the first court I told Natongo Zua. Natongo Zua had been illegally terminated from being a speaker of the South African Parliament. She sued in time. They told her, you know, it was illegal, but we can do nothing for you. We cannot even give you damages. She appealed. When she appealed, the court was clear that you are a judicial body. You can do anything on earth to give justice. And she got damages. She got many remedies from that court. So that shows anything is possible. You cannot tell us that if the amendment was illegal, that the consequences can be lawful. It's like someone taking your land, stealing it, he constructs a house. When the court finds that actually there was fraud in taking your property, of course he has to vacate. Yes, you remember when when Mohanji took over Qualisale bus terminal. Yes.
And the Kyagulanyi lying case, you call him a liar.
That is still pending. The only step we finished was the state taking over the case from me, which I'm still protesting, because the law allows us to file private prosecution. You see, presidency is not something to joke with. You know how much powers the president have. So if you have a liar... So
soon you may charge him about lying about his car.
No. I'm still on age.
I mean, whether this is what you're saying. Someone who wants to be a wannabe president
cannot be dishonest.
Cannot tell lies about cars.
And that's what
should we await for you charging, going to court about the armored car and so on?
I think that car conversation is just diversionary. We are dealing with serious issues of a fake election, of a person going to court, failing to present his case, and then saying I'm withdrawing it, of a Chief Justice who is conflicted, and then you're telling us a car.
Yeah, but
I think this is
I would agree with that last statement. But you are the same one who was suing Kyagulanyi over age. You are suing NUP over NURP. And
I've not sued NUP over NURP. No.
There are many comments in which you wish to join that NUP, NURP, and then eventually that was a different case altogether.
Yes, but I'm saying, you see, fair hearing.
Yeah.
Whether Kyagulanyi is a common man who stopped in P2, whether he's a farmer, whether he's a convict, he's entitled to fair hearing. He's entitled to rule of...
Finally, yes. On this string, Supreme Court judges got tired of Mr. Sebaduka
yes.
for insulting them and jailed him. I'm not sure, is it 3 years?
For 3 years.
So do you ever envision that Malema Birizi judges might one day get tired of him and throw him in for the 3 years?
I don't think I'm a Sebaduka of sorts, although I disagree with the way they convicted Sebaduka. And I've actually challenged that decision personally in the East African Court, because I believe...
You open that window of challenging in the East African Court?
Yes, because otherwise you're going to suffocate here. Because the Supreme Court, the last court, says you have abused us. It says now, can you defend yourself that you have abused us? They charge you. They hear you. They say, now we have convicted you for abusing us. Now we are sentencing you to 3 years for abusing us. We say, now what is this? This man cannot appeal. Yet, if they are saying that actually he did contempt of court, the best would be to forward his file to the police. Police forwards it to Bugan Road Court. Then the man is tried. Evidence comes. Then it's convicted. If not satisfied, he appeals to High Court. But now the man is 3 years in prison without any option of appeal. But because Owunyi sat with his other 6 colleagues and said, why do you call us a council of fools? Why do you abuse us? But at the end of the day, judges are public officers. They are supposed to be scrutinized. They can even be abused, actually. They can even be abused.
So, Justice Owunyi Dolo says he will not recuse himself. He will not step down. What is it that made you think that he would step down where others haven't?
You see, Justice Owunyi Dolo should blame, I think right now, all his integrity is down. All his integrity is down.
Why would you say that?
Why am I saying that? Because it is plain for every person to see, for every reasonable man to see, that a former lawyer of a person cannot sit to be a judge of that person. It is such plain. But this judge is telling us, I cannot recuse. So it's about his integrity.
I think that is a very weak argument, because...
how weak is it?
Mr. Mabirizi, if you are my lawyer today, and 10 years later, the one you are defending me against also hires you, you could very well be his lawyer. Your integrity wouldn't be questioned. It
will be questioned, because the advocate's rules says an advocate shall not prejudice from a client. Yes, you cannot be
10 years later, 15 years
even
later,
if they are 20.
You've moved on. I
even
mean,
if they are 20.
We have people, Justice Kanyamba was even Attorney General, Bart Katrebe was also a minister. So the president...
Look here.
There's a lot of precedent.
I answered that, that the difference between all those are government positions. A government officer is serving the Republic of Uganda. You appoint him, he goes to Parliament for approval. He's accountable to Parliament. Everything he does goes to what? But this is a personal lawyer. And under the Advocates Act and the rules, that relationship has confidential part. You don't divulge anything, you discuss. So you have people who have been discussing confidential things. Confidential things. Then one of them comes and says, now I'm your judge. Reasonably, you cannot tell someone that you are giving justice. So Owunyi Dolo, to save his integrity, that was plain to her. He would have told Justice Chisache, who is the most senior, that please preside over. This is a matter we have conflict of interest. This is my former client. Because it's two-way. Assuming Owunyi Dolo and Museveni ended up bitterly, maybe Museveni never paid. Would Museveni get justice before Owunyi Dolo? No. Assuming he paid him passionately, can he rule against him? So to avoid all that, the standard which has been set internationally in UCAN world over is look at the test of a reasonable man. And it's about perception.
Yeah. I like the way you say reasonable man, because the judge asked you whether you're reasonable. But don't you think presidential activity should happen I mean, if the Chief Justice has gone to visit, not necessarily to visit the president, but to conduct business where the president is attending as a guest of honor, that's presidential duty.
Oscar, international standards, look what judiciary, they protect the judicial arm through perception. It's about the perception. You must have a perception that the judge is independent. And I warned Onyedolo about, again, self-conviction. Like, for me, I feel I'm independent. So what's the perception? There is a case pending before the Supreme Court. The presiding officer is Onyedolo. He's the Chief Justice, right? But he has a deputy. Now, tell me, what's the perception? I think if you have a son or a daughter at university, that son is reasonable at that level.
Yeah.
Now, he wakes up in the morning, he reads the Daily Monitor, New Vision. The person who was sued is standing with the person whom he sued. Now, for you are covering it. This is official. This is no, but the reality is these people are meeting you here.
Well,
it's an official interview. It's you on your job.
Yeah.
But assuming tomorrow I'm saying that I'm going to be your judge, people will ask, but we saw that same way with Maviris the other day. Can he judge properly? So to avoid all that cloud, don't visit Museveni. Send your DCJ. Send the deputy. Because
we are waiting for, because he has said that the explanation will be included.
But he gave part
in
of
the
it.
But he gave part of it.
Part of it in our
but,
interaction.
Another thing he says that you people criticize him in places where he cannot respond. He's put you together perhaps with NUP people.
No, in places where he sits in that court. And if you criticize him, he's the head, the Chief Justice is the administrative head of the judiciary. He can speak. And he has been speaking always in court, even where he was not supposed to speak. Like when he said, if you want to do your plan B, go and do it. So was plan B in the pleadings? Was it in the affidavit? No. But he used his court as the administrative head to say so. But point is, Onyedolo is actually damaging the image of the whole judiciary. Because now he's at the pyramid of the judiciary. He's sitting in a case of his own client, former client. Now, assuming what will happen to a magistrate in Ibuama, what will prevent him from sitting in a case of his neighbor? Simple. He will say, but I'm independent. I took oath. Because even the CJ said he took oath. So that's how the justice system is going to collapse. And then we shall go back to that people sorting out themselves. You steal me, I beat you. Because the justice system has been weak. You find a monkey sitting in a case of a forest. They ask, but you, Mike, how does he say? I'm independent. I actually took oath. Yet every judiciary take oath.
Let's stop for a break. Thank you for watching NBS Face Off. I am Oscar Semoya Msoke. This evening with Mr. Male Mavirizi Kanso, and I've accused him of being a legal activist who thought the Chief Justice would step down. Mr. Mavirizi,
yes.
I think there's a bigger problem, and maybe you should have been attacking the bigger problem. Maybe the problem is, why would the judiciary have to meet the president about their budget?
No, actually, that's not a problem. That's not a problem.
Because then if it isn't a problem, then there was no problem with that particular meeting.
You see, you are giving people an impression that Onyedolo is the judiciary. No!
I'm giving an impression that maybe Male Mavirizi is unreasonable and that Onyedolo is the Chief Justice.
Onyedolo is the Chief Justice in a system where he has a substantive Deputy Chief Justice, where he has a substantive Principal Judge. Those are the three heads of the judiciary. They are all substantive. Not at the time when Kavuma, you see, at one time Kavuma was the acting Deputy Chief Justice and acting Chief Chief Justice.
And he never recused himself from any judgment.
But Kavuma had never been a Museveni lawyer. He had never been a Museveni lawyer, although he had served him as minister. But the point is, the judiciary is bigger than Onyedolo. But Onyedolo wants to make people think that he's the judiciary. No! You would have sent Butera for that. But it's about perception. You see, people are losing credibility in your system. And you are saying, yes, I'm a Chief Justice. Yet that I told you, Onyedolo, that the justice system is as fragile as this glass. The moment you mishandle it, whether recklessly or what, sure, it will break. But for him to think that the justice system is like a plastic cup, so that's his difference. Yes.
So will you join the Kyagulanyi petition withdrawal?
Joining or agreeing with it?
You could give me the legal term.
Maybe agreeing with the withdrawal. I don't agree with the withdrawal.
You disagree with that?
Yes.
You don't think this case should be withdrawn?
Yes, because...
So will you apply to join the case to disagree that the petition shouldn't be withdrawn?
No, I don't have the capacity to join, because that capacity under the law, under section 61 of the Presidential Elections Act,
requires a petitioner.
Yes, and the Constitution, Article 104, they require a candidate. Yes.
Sorry, a candidate.
For you to be a petitioner, you must be a candidate. So I wouldn't join. But why I don't agree with it is that Kyagulanyi and his team, they failed the test which the law gives them. They failed to treat this case with the importance it has. So they made it simplistic, as if it is their personal case.
So they should be punished for it?
Especially the lawyers. Segun and his team actually should even face the law council for incompetence. They have been so incompetent in this petition.
In what way have they been incompetent?
You see, you meet a client, he tells you, I want to sue. They stole my votes. Actually, not my votes, they stole Ugandan votes. They tortured people. They switched off internet. They did many illegal things in this election. Can we sue? You tell them, yes, we can sue. Here is my evidence. Okay, being my evidence, let us draft a petition. You get time, you draft a petition. On a Friday, 28th, you write to court, to Supreme Court, that, hi, I want to come there on Saturday and file my case. The court tells you, don't mind, you can come on Monday. It actually gives you 2 more days. You come on Monday at 3. You file a petition. You say, this is my petition. You see, this presidential petition must be the finest work any lawyer would have done, because it comes once in 5 years. Some 5 years it doesn't come.
Did they have ability to produce the finest work any lawyer can do?
They don't have what?
Did they have the ability to do that? Their client had been jailed at home.
No. That had been washed away the moment they decided to sue. So their client was even able, even after that incarceration, he was able, he said, I can. And he even beat the deadline of 15 days. He said, I can. And they also told him, yes, we can. That's why they came to court. But then after filing, I read through it and I said, now, this is just a mockery of a petition. Within 2 days, they were at court. We want to amend. Now,
you're the lawyer in this conversation.
Yes.
So I guess you know how much we can talk about it and how much we can't.
No, we can talk about everything.
Yeah.
Because at the end of the day, we are not parties to it. We are not lawyers to it. And
there's no judgment yet. So.
And they are withdrawing it. So they have opened it up.
If they're opening it up for withdrawing,
so at the end of the day,
it can be discussed.
They are saying we are withdrawing. Then you say, you people, were you sleeping before?
They've given reasons. They said that you've attended to one reason, which is the Saturday thing not being given enough time.
No.
Add on to their affidavits, not to amend the petition,
Saturday,
not to have a recusal.
No. I will come to that. But before that, they are saying we want to amend. So I've been giving people an example. You tell someone, this guy has failed to pay me my money. Here is a contract. I supplied timber worth 100 million. He didn't pay. He tells you, give me the contract. You give him the contract. He tells you, pay me the money. You pay the money. He tells you, on Monday I will sue. You say, counsel, have you filed? He says, first come and sign. You come and sign. He files the case. Then Oscar, on Wednesday, he tells you, hello, Oscar, do you know I forgot to put there the agreement from where I sold the timber to the person? Want to amend now to include the agreement. Oscar, you just say that actually this is a non-serious lawyer. This is what they're doing. He gives you everything, then 3 days you want to amend. That was incompetence. Now they are blaming court, that court refused them to amend. In the first place, who made a weak petition to be amended? It's you. Then we just come to affidavits. Normally, if you saw Raila Odinga filing,
a lot of people thought that Amama Mbabazi's petition was weak, but the Chief Justice then seemed to imply that he also thought it was weak, but he allowed them to amend.
Circumstances were different. One, Mbabazi never applied for amendment formally within 2 days. Mbabazi came at the time of hearing, now with a new lawyer. Essentially, he had, I can put it a Michael, and Savino of Novosinje. They brought a petition which was weak. I saw it being brought, I think it was about 10 pages. Afterwards, before hearing, he hires Muhammad Mbabazi. Mbabazi comes, tells judges, I've just gotten instructions. Look here. I've read the petition as a new lawyer and senior to these people. I see there's a problem.
Same thing. Semantics.
Not same thing.
The petition was amended.
Not same thing. Not same thing. Here, the same Segona who filed the petition comes and says, Miss Segona, I want to amend. So what's your problem? Have you discovered anything new? You are the same lawyer. You would not allow that amendment to happen. Because this is the same lawyer. Is he fooling you? What is it? You see, when the lawyer is different, there is an impression that maybe the former lawyer, why he hired a new one? Because the other one had weaknesses. So
okay.
this same lawyer,
you're going to the other points.
I was telling you, if you saw Raila Odinga filing his 2017 petition, he came with a full pickup, full of all the affidavits. Almost all. Most of the affidavits were filed together with the petition. Kyagulanyi came to filing the petition with only one affidavit, his. 11 days down the road, by 11th of February, no single affidavit had been filed. Either affidavit. So Segona tells court that he had 50 affidavits waiting to be filed. So they agreed on the time within which all the affidavits shall be filed. The time lapsed, they had filed only 50. And on the last day. So they are telling people and the court that we have left out 200 affidavits. Now they come to court, allow us.
Because they were under the impression, as it has been done before, that they'd be allowed to file extra information as it came along.
That is foolery. That is foolery. How could they be under that impression when they attended a proceedings where they were given time frame? So they were given time frame when they were there. They were given time. They agreed to the time frame.
One would argue that in the previous petition, where there was even more time, they allowed extra evidence as they went along.
That would be argued actually. That would be argued before you agree to the timeline.
Right.
But you agree to the timeline. But secondly, there are many differences between Besigye petition and Mbabazi petitions and this petition. In this petition, these guys had 15 days. Besigye had 10 days.
So, what are you saying? That
it's a matter of incompetence.
This is a case that should go to LDC or law school to study for how not to do things.
How not to be negligent.
How not to be negligent.
Yes, and other lawyers to learn that actually a presidential election petition is serious. That's why you have even seen them gambling with withdrawal. They thought it was a normal May Land case. That's why someone goes to come and says, I'm withdrawing the case.
This is going to be music to the petitioners, the Attorney General, the Electoral Commission, and the NRM party.
Yes, because
statements.
For them they are saying, I'm withdrawing. But the law says, no, it's not a mere withdrawal.
No, I'm saying the comments you're making, music to the Electoral Commission, Attorney General, and NRM party.
It's up to them, maybe. But to me, as I told you, I need to be clear on this. Some things we need to speak clearly. Because we're here for the country. Tomorrow, people are going to do the same things.
Okay.
And
let's stop for a break, and then I'll ask you about what if another candidate takes up this petition. You're watching NBS Face Off. I am Oscar Semoya Msoke this evening with lawyer Male Mabilizi. So, how would it work? Because social media, nothing confirmed yet. How would it work if candidate Willie Mayambala were to take up this petition? It would be an exercise in futility.
Not in futility. You see, when you look at section 61, subsection I think 3 of the Presidential Elections Act, it tries to give a framework of how a new candidate can come in. But the principle in all that is that this petition is not about this candidate. And what I had not told you, that what I was calling a gamble, the rules say, before you withdraw, you must apply to court that I want to withdraw. But support that application with 2 affidavits, 2 statements on oath of the petitioner that have not been bribed, have not been compromised, and of his counsel. So the bigger picture is, this is not your case. This is the case of the whole country. And why now it continues to replacement? That they don't want a situation where a candidate who not actually have won the election makes a deal with this petitioner, and then he becomes a president, but without the will of the people. So that's why they allow a new candidate to come in.
Yes, I'm going to come back to.
But the framework is saying,
yes.
You say how possible is it? It is possible. He can again continue using that evidence filed. He can again continue using the security for cost which was paid, which was 1 million paid by Kyagulanyi to court. He can again, court can again make an order that Kyagulanyi will pay the costs,
yes,
incurred by Mayambala.
Well, that is fair enough.
Yes.
But then, if the 53 affidavits were compiled by the Kyagulanyi team, how can they be beneficial to Mayambala?
No, Mayambala has the right to bring other affidavits.
Oh, will that be permitted?
Yes.
Because remember, the last judgment was that no more affidavits.
Yes,
are allowed.
because this was a petition.
Because the case must be closed.
The case
on
was
18th
the
of
case
March.
was called Kyagulanyi versus Museveni. So the circumstances are now new. Mayambala says, "Here I am. Have been actually. I'm puzzled that this former petitioner was fake. So here I am. Seriously, I have give me 2 days. I bring my evidence. Yes, evidence can come in.
In Uganda, you do know that the state is very powerful.
Yes,
and you do know that if a lawyer,
so
you yourself, you know,
in which country,
the troubles you have had in sometimes filing and so on, you do know that it is not an easy exercise.
So in which country where they say is not powerful?
No, i.e. that you mentioned perceptions. Yes. So if you have a perception that Malema Birizi comes over and comes and takes over a Kyagulanyi case, then the perception is maybe perhaps Mabirizi is the one who was bribed. No,
the perception is built by those fake people. Because they, like I heard Segona saying that guy, they have hired for him lawyers, but that propaganda is built by that clique who want to think that they are the real opposition against Museveni, and whoever comes must be viewed as a Museveni agent. Because then, if the case goes through, it might actually legitimize the election. No, now, why did Kyagulanyi go there? If it's about legitimizing, why did he go there? Did he go there to legitimize? Perhaps he went there and then he's found out because of the powerful everything, it doesn't work. And no, all these things have been here when Kyagulanyi was here. No judge was appointed yesterday. They have been here. So the point is that they have that fake propaganda they spread. Like Mayambala, they are saying he has been spread, but Mayambala is a poor man. He even failed to campaign because he didn't have fuel. Even he's sleeping at his father's home, his mother's home. And that's the other one. That's Katumba. Mayambala, Mayambala is running his own family. The same media, as far as he told me. The same media has been making stories about him, and he has not sued them, saying that he's sleeping at his mother's home, he's making the guards to sleep in the compound, guarding him, and he has not actually not campaigned. I think campaigned about 20%, and he was saying he didn't have money. So he now was in the media. He was in the media. Yes. I think you're talking about the other one. No, I'm talking about Mayambala. And now the same group is saying he has been compromised. So I think we must understand to appreciate every person who comes up. You file the case, you are throwing it away, you are running. It's a bit rich coming from you when you say you must understand and you must go with someone. Those are not the same things you're talking about, or we judge Justice Owiny-Dollo. No, Justice Owiny-Dollo's case is so different. And that's the understanding I'm talking about. Yeah. You must understand it is so different, yes. But it's so different. The perceptions. You don't allow anyone to have a perception on Willie Mayambala, but you allow people to have a perception on Justice Owiny-Dollo. I'm not saying that people should not have a perception. Now, the perspective on Willie Mayambala should be the vice versa about what they are perceiving against him. Willie Mayambala, every time we have seen him in the media and everywhere, he has been a poor candidate. I think that's why he even came last. Because I think the farthest he campaigned, I think, was impeached, and he failed to go even to up-country places. Everywhere he went, he had, I think, that small microphone, that small small thing. That's where he could speak from. So I don't think that at this time we should say if he's coming up. You're indicting him. You're indicting him. In other words, you're saying even if he came up, he might not be able to take up that petition. Yes, conclusion. Or on the financial side. Yeah. I don't think if he didn't campaign much on any side. Yes. No. Even if he did campaign much, there are some aspects which don't require those DRR forms. Switching off internet, do you require a DRR form? Switching off mobile money, do you require a DRR form? Fraudulent tallying at Kyambogo, do you need a DRR form? No. There are some aspects, and those aspects are the key aspects under which the courts in Kenya and Malawi nullified the election. They didn't nullify the election because they compiled many DR forms from all over the country and counted the votes. No. They nullified the elections because there are procedural glitches which nullified the process. Yes, those don't require that. But maybe my worry with Mayambala is the financial aspect of it. The financial part of collecting the evidence and hiring lawyers because they cannot argue it the way it is. Yes.
So, finally, what next for Malema Birizi? Does he see himself going back to LDC and getting that certificate that should enable him to practice all the time? Because what's on the table is that he's not going to stop being litigious, and that perhaps he will continue being a pain in the courtrooms.
I don't admire to be an advocate, and I don't intend to go to LDC. That was a decision I made at my 4th year, and I'm contented with the decision.
One would think you've grown wiser.
No.
And with all the
cases
you've handled.
I've gone wiser that actually I thought so right not to go for that certificate. I'm now not controlled by those judges. I'm now not threatened that law council will do this and this. And
there's a precedent that they can lock you up for 3 years because they don't like you
as a common man. They can lock me up as a common man, but not as an advocate. Not as an advocate.
Sebaduka was locked up.
And actually, let me tell you, my colleagues, my classmates who went to LDC, they're not doing what I'm doing. They fear. They fear to lose clients. They fear to do what? They fear. But for me, I'm a Ugandan. I will remain who I am. Actually, going to LDC will weaken me. Will make me now. Will put me in some box of regulations where a judge can say I'm suspending you. Like just one time suspended Freddie Mwema from commercial court. Is it for 2 years? So for me, I think it was wiser for me not to go there. And I'm not here. I'm not seeking to be hired. So why should I go there? I don't have.
And did you expect the Law Society to join you in that case, in which you wanted Justice Owiny-Dollo to step down?
If it was a vibrant Law Society, but it is now so weak.
Why do you say that?
It is so weak. What is it doing to promote rule of law? They're supposed to promote rule of law. But in every conditional thing, they just keep quiet. They make fake COVID laws. They even failed to sue when Museveni made fake COVID regulations. They saturated the draft and then they slept. They're just weak now. They are just maybe, they make some press statements which don't matter.
They are watching you now.
Yes, they killed 54 Ugandans officially. No suit by Uganda Society. It's me who went to East African court. But they have killed 54 people by shooting because they are demonstrating. And a vibrant society is just quiet. They just make statements, and the other day I had their president saying, you see, we are waiting for clients. If someone feels that a person was killed, let them come here and help them. But that's not the Law Society which the Njubas headed. The Njubas had Law Society which was vibrant, that even the dictators arrested them.
Have you returned to the Uganda Law Society?
For what? I'm not their member.
To express the disappointment you...
I don't need... I can sue my cases. Why should I write to them? When I feel that there's something, I go to South African court, I go to High Court, I go to Supreme Court. So let them be sleeping. People will understand that actually they have become part of the regime. Actually, they are now a department of the state.
And finally, with all these losses that you're piling up, how will you sustain yourself? I mean, law cases cost money. Even going to Arusha costs money. Of
course, costs money. I'm fundraising. Some people contribute, and just like how have you sustained yourself throughout this life? Somehow you survive. Somehow you survive, but you don't fear to leave because how will I sustain myself? Otherwise, we would remain in the villages. We wouldn't come to Kampala because Kampala life is hard. But don't we come? So somehow, as long as we have the principles which we are following, yes.
Lawyer Malema Birizi, we can't shake hands, but thank you so much for appearing on NBS Face Off.
Welcome.